like a inmate holding cell down at the Orange County Courthouse.
Yeah.
Crazy story.
Absolutely crazy story. I mean, she was there, I think, it happened Friday night.
Mm-hmm.
Basically the courthouse closed. I assume they come in at night, start cleaning, happened Friday night, and they didn't find her till Monday morning. Somebody, I guess one of the security guards or someone opening up the courthouse.
Saw her cart or
Saw
something
her cart
like that.
outside the holding cell and realized what had happened and went over and let her out.
And the scary part about it is she was diabetic and
Right.
2.5 days in a jail cell with nothing but trying to get some water out of like the top faucet or something like that from the toilet, where she was able to get clean water from that. But she survived on that for 2.5 days.
Yeah, I mean, pretty horrific story, honestly. I mean, fortunately, she survived, and there was no serious damage. I don't think she went to the hospital or anything like that, but certainly very traumatic.
Oh yeah, she's in the hospital.
Oh, she is in the
yeah,
hospital now.
she went to the
Okay.
hospital the very next day.
Okay, because I think when she first got let out, they said she didn't need the hospital.
Right.
Okay, so I didn't realize that she went the next day, but
And I think that's part of the whole diabetic thing, I guess,
I'm
just
sure.
to make sure.
Yeah.
So my question to you is, of course, everybody's like, automatically my head goes, uh-oh, there's going to be a lawsuit there. So, but could there be? Like, what happens with that when it's nobody's fault, really? It's a faulty lock. She didn't have her phone on her. What happens in that situation?
well, I mean, I would say this is America. Anyone can sue anyone for any reason.
Oh,
but
yeah.
that doesn't mean there's not legitimacy here. I mean, my understanding from what we know so far is that this was a new position for her. She was new to the job. So you kind of, my mind immediately jumps to, what kind of supervision and training did this individual have? How was she left in there for 3 days and there wasn't another employee who realized that she was missing it? That there wasn't some sort of chain of command.
Right.
So that's the first thing that jumps into my mind. I don't know if the lock was faulty or not, or if she just closed the door without the keys in it or something like that.
It says, so the woman said she entered the cell to clean it when the door shut behind her and she was unable to open it and unable to contact anybody because her cell phone was left on her janitorial cart, which was outside in the doorway.
Yeah, so I mean, there certainly could be a lawsuit here, and obviously, the medical issues aside, just being locked in there for 3 days would be very traumatic.
Absolutely.
You add the medical issues on top of that, her not being able to get her insulin, not being able to get food, very limited water. I think it was out of a spigot or something in the cell. There could certainly be a lawsuit here, but I do kind of wonder, what kind of training was there? What kind of supervision was there? And obviously, this is somewhat, I don't know if I want to call it a dangerous condition, but it's certainly something that they're aware of, because I think she was told a little bit about this beforehand or advised that the cell's locked or something like that. So is there enough training there? Really, there should probably be a procedure, I would think, that everybody on the cleaning crew who goes into the courthouse comes out of the courthouse.
Right,
Or
yes.
something along those lines. So you kind of wonder what kind of procedures did they have in place and what was really going on there.
Plus, too, I think the courthouse, if I'm not mistaken, I think they have 24-hour security there where people are walking around, and maybe you don't go up there because there's not going to be anybody in there left over the weekend. But like you said, the theme parks, everybody's accounted for.
Yeah, I mean, there is security on the weekends. They're also an outside company. We should mention this cleaning company is an outside company hired by the county. It's not a county employee, as well as the security is as well. I would assume, and this is just my assumption, that on the weekends the security is probably just kind of patrolling the entryway and kind of around the exterior of the building because, like you said, they probably assume nobody's up on the 23rd floor.
Doors are locked. Nobody's getting in.
I assume the elevators are shut down, things like that. So nobody's supposed to be up there. Again, I don't know that that's their procedure, but that's what I would kind of guess.
Right. So, all right, another question for you then. Technically, she never got off work, even though she wasn't cleaning.
Right.
She was at work for, 70 hours. Is she due those wages?
I mean, arguably, she was still on the clock for those 70 hours.
Never clocked out.
Against her will, obviously, but
Right.
she was still on the clock. So, yeah, I mean, theoretically, she could have a claim for a wage and hour violation if she's not paid for that time. No different, really, than if an employer calls you into a meeting that you're forced to be in, you have to be paid for that meeting, essentially, even if it's not directly related to your work. If you're required to be there as part of your job, then usually they have to pay you for it.
Yeah, I mean, lawsuit aside, whether she would be able to do that or not, I'm just trying to think about this poor lady. That this is like my worst nightmare. Elevators and tight, closed spaces are my biggest fears. in the world. So if something like I started sweating when I read this story at first, it completely freaked me out. So just hopefully at the end of all this, she's okay. That's, mentally and physically, because that's traumatizing.
Extremely traumatizing. I would be surprised if she returned to work, but I guess we'll find out. I certainly wouldn't want to go back to that job after that experience.
Absolutely not.
Fortunately, at least she is physically okay.
Absolutely. Wishing her nothing but the best. So, all right, well, let's get to some of these questions now that I got mine off my chest that I wanted to ask about this poor lady that happened to. If you do have a question, you want some advice from Mo, you can send an email, and we've got a whole stack of them here today to get to, ask@DeWittLaw.com. And if it's easier for you, you just got your phone there, but you don't have your computer going, you can call 407-53 Moses, and you can leave your question in a voicemail right there, and we'll just play it back here on the show, just like it would be calling into the show, and then we will get you some advice from Mo. So let's start off with this one. He says, Mo, I got a DUI in another state. It happened more than 20 years ago, and they added an eluding charge to me. Now, this is the only charge I have ever had on my record. No speeding tickets, no nothing. This is the only thing. Said I moved to Florida 2 years ago, and I tried to take the concealed carry training course, and I applied for my permit, but I was denied. I guess the law states I can still buy a weapon, but then how would I transport it without getting in more trouble to range or go hunt? And how do I get this ridiculous charge removed from my record more than 20 years ago?
So, the only option you may have is to look to see if it qualifies to be expunged.
Mm-hmm.
And we'd have to check on how the expungement works with the concealed carry, because the concealed carry is kind of a different aspect of the law. It's not like a regular criminal charge, but typically, if that's the only charge you ever had, and you said that was the only charge you ever had, but you also mentioned a DUI, so I'm not sure if
DUI in another state, and they also added the eluding charge, so it was I guess the two
together, but still two charges.
Yes,
technically. Still two charges.
You are right. One arrest, two charges.
Yeah.
I follow now. Okay.
Yeah. So it kind of depends what happened with those charges as to whether you qualify to have them expunged or not. But that would be the route you probably want to look into, is to see if you could get them expunged. Basically, you get one expungement in your lifetime.
Oh, you do?
Typically, depending on the charges.
Is that a Florida thing or is that a national thing?
It's a Florida thing as far as I know. I assume many other states follow that, but I can't say that for certain.
Okay.
But you typically get one free one in your life. It does depend on the type of charges, though. Typically, violent crimes, more serious crimes don't qualify. You have to have a pretty clean record. Usually, it's a one charge thing. That's why I mentioned the two charge issue.
Shoplifting when I was 19.
Right. That's kind of the intent of it. They don't want one stupid mistake to ruin your life type deal. But if you pled to both the DUI and the fleeing and eluding, you may not qualify for the expungement. So we have to sit down and look at your complete, criminal history and see if you qualify. Also look to see what state this occurred in and what their requirements are. And ultimately, you'd have to hire an attorney in that state to petition the court for the expungement.
Gotcha. So it potentially it is possible to get it removed. Just a lot of steps that you got to go through first.
It can be possible, and it does take a little while. It usually takes about 1 year to 2 years for an expungement.
Okay, very good. Let's get on to this next one. Mo, I have a popular name brand recliner. Was not cheap, but it's been broken for over a year now, and he put in quotes, or she, parts are back ordered, is what they keep saying. Is there a law about reasonable time to repair, or is there any kind of code to force them to repair or replace it within a certain amount of time?
So I'm assuming it's still under warranty. If there's no warranty, obviously they have no obligation whatsoever. Now, there is a whole treatise on warranties, and
we could spend days.
I cannot remember it for the life of me. I've blocked that out of my memory as well as I could.
Nothing wrong with that.
Yeah, but I think there is some sort of provision as far as, reasonable time to repair. Now, given everything that's gone on in the world, the term reasonable may have changed a bit, right?
Right, yeah.
So we kind of have to dig into it and see what's going on there. I mean, the other option may be to see if there's somebody else besides the manufacturer who could repair it and what that costs, and then ask for reimbursement if they're able to use a different type of part. But I'd have to dig into the warranty treatise and see if it applies here, and then see what the options are. But I think typically it's kind of a reasonable time frame. But like I said, I mean, the world's become a crazy place over the last few years. Supply chain issues and everything else that we've heard about endlessly. So, if it's a legitimate issue where they just can't get the parts, that may, maybe the problem.
But if
There may
they're
not be
fixing
much.
everybody else's except for yours, then you might have an argument.
Yeah, or if they're using those parts to create new recliners and not servicing the ones that are within warranty.
I
that
got
could
you.
be another issue too. Basically if they're using it just to create profit and they don't want to take care of their existing customers. So you have to kind of look at all those things. And I don't know how long it's been for this person. If the recliner's functional or not. I assume it just can't recline, but it can sit there. So
Right.
hopefully you can use it a little bit. But
Pillow holder, clothes hanger, like my treadmill at home.
Yep, exactly.
All right, this one's short and sweet, but it might be a detailed answer, and if it is, you can just tell me, and we'll save it.
Right.
Since we got a couple minutes left, my friend has been charged with domestic violence. There was no cop present, with someone else saying that she did it. There was a mark on his face, but he did that to himself, not her.
Well, we see this all the time, frankly. Domestic violence cases are often he said, she said, or he said, she said, she said, because domestic violence doesn't necessarily, it just means you live together.
Right.
So, we see it all the time, and ultimately it comes down to credibility and who they believe. You're going to have to take your case in front of a judge or a jury, depending on whether it's an injunction or a criminal case. And ultimately, it's going to be up to who they believe. And it can be a very scary case because, sometimes there isn't a lot of evidence.
Right.
Sometimes you wish you had the video evidence because it would exonerate you. But, ultimately, it's just going to be your story versus theirs and how the marks got there and things like that and whether the stories add up. And ultimately, whether the judge or jury finds you credible. So it can be a scary thing. I definitely recommend you have an attorney to go through the process. But it can be very scary, and there's not a whole lot you can do about it until you get into court to fight it.
So I guess if that person says it and everything just kind of adds up, whether or not there was a police officer present or not, if the judge believes that person, no matter what happened, get
and
some help.
In Florida at least, if somebody makes an accusation of domestic violence, typically somebody's going to jail.
Right.
I mean, that's usually the case. It's very rare that doesn't happen. Anytime I say something's rare, a listener calls in and says, "Oh, that happened to me." Yeah, there's always exceptions, but for the most part, if someone makes an accusation, somebody's going to jail, and then ultimately it's up to the state attorney whether they want to pursue the charges. If they have a victim who's cooperating and says that it happened to them, typically they're going to pursue those charges, and ultimately, like I said, it's going to come down to credibility if there's no other evidence to support it.
I just learned something, that domestic violence means you live together.
Yeah.
I didn't realize that. So, like, if two brothers live together, would that be?
Yeah, exactly.
If somebody punched somebody?
Yeah,
but if
family members.
But if two brothers lived 6 miles apart, one in Longwood and one in Castleberry, then they got into a fight. That's not a domestic.
Well, right, then that would be battery.
Battery.
Yeah.
See, I'm learning all kinds of stuff here this morning. Very good. All right, well, if you've got questions, feel free to send them to us, and we will try to get to as many as we can this morning. Again, if you do have a question, email it to us at ask@dewittlaw.com. That's ask@DeWitt, DEWITT law.com. Or once again, you can call 407-53-MOSES and leave a voicemail right there, and we'll get to your voicemail, play it over there, and then get you some advice from Mo. And don't forget that if you do need legal advice, whether it's here on the show or it's just something that you'd like to ask them not on the show, you can always get legal advice. Call anytime, any day of the week. Call the office, 1-800-DeWitt-LAW. Again, it's 1-800-DeWitt-LAW, and they will be able to put you in touch with somebody that can definitely help you out. More of your questions and more advice from Mo DeWitt of the DeWitt Law Firm. You're listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. I got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney, so I wasn't really sure what route. I reached out to a friend of mine, and she was just like, hey, I have someone you can reach out to. And she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing, they're mailing out a letter, anything, I'm always in the know. So that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm. If you've got questions for legal advice, you can call the office anytime at 1-800-DeWitt-LAW, 1-800-DeWitt-LAW. Mo might not be the guy answering the phone if it's a Saturday afternoon at 2 o'clock, but his team is right there to help you whenever you need it, and they can always get in touch with him and his team of attorneys to give you some advice. Again, 1-800-DeWitt-LAW, or if it's just something you want to ask here on the air with us and get some advice from Mo, ask@DeWittLaw.com is the email, or by calling and leaving a voicemail, 407-53 Moses goes right to Mo, and then we'll get your question on the air for you. All right, let's get back to your questions. Mo, can I receive alimony or some sort of support after being in a relationship for nearly 30 years, but we never got married? I guess the whole Goldie Hawn type thing. Lived together, no kids, never felt the need to tie the knot, but now it's come to an end, unfortunately, and he's always worked and supported the two of us. That's got to be a tough situation to be in.
It is a tough situation, and Florida does not recognize common law marriage, which is basically what they're describing here.
Okay.
And frankly, over the years, we've had some pretty wacky and crazy cases before where, a couple got married in a ceremony, but not legally married in another state that recognized common law marriage and then moved here.
Oh, wow.
And the question became, did Florida recognize that common law marriage under full faith and credit and what we call the doctrine of comity, COMITY, not comedy like a comedy show,
right.
As to whether we would honor that type of marriage. And the answer ultimately was no. Florida would not recognize that because we don't recognize common law marriage at all. So, unfortunately, the answer is simply no, you're not entitled to any alimony because you weren't legally married. Now, still any assets or property that were accumulated while you guys were together that are in joint names, there may be a component where you're entitled to a portion of those. Typically if the house is in both names, even if one person paid for it, they can get credit for that. But they're, typically it's a joint effort. You're putting money together. It kind of becomes commingled. It may be hard to determine exactly who's entitled to what, but there's still a claim there, and you have to kind of unravel that a little bit. If you have completely separate bank accounts and separate assets during this quote-unquote common law marriage, then you both kind of go your separate ways and aren't really entitled to anything from the other person.
Man, that is hard. I mean, I think I'm just like picturing everybody's mom right now. You're in a great relationship or whatever, and everything's going just fine, and after 30 years, you call it quits, and he always said, or she always said, you don't need to work. Just, stay home, take care of the kids. Granted, she said she doesn't have the kids, or it doesn't have any kids or anything. It was just the two of them. But all of a sudden now, after being together, so I'm sure that they've got to be at least 50 years of age or older. Now, all of a sudden, to try and figure out a career and start to support yourself at this late date in the game, man, that's got to be frightening.
Yeah, I mean, a marriage is really just a legal partnership for the most part, in the eyes of the law, I should say. You're basically just like with a business entity, you're forming a partnership. So basically everything that's owned by the partnership is, a certain percentage of the partners, right? So in the marriage, typically there is two partners, and it's split 50-50. It doesn't really matter how it was acquired. If it was acquired during the marriage, for the most part, there are some minor exceptions. It's split 50-50. And that's basically a contract or an agreement that you're entering into by getting married. When you don't get married, and if you live in a state like Florida that doesn't allow common law marriage, then you don't have that partnership. You don't have that agreement because you do have to kind of agree to that arrangement. So, that's just part of life, basically. Either you agree to it or you don't, and then ultimately you're stuck with either circumstance or consequence. And depending which, if you end up getting divorced or if you stay married or, which side you're on, it may or may not be beneficial for you.
So she needs an attorney. She needs to call you.
Well, you should definitely get the advice of an attorney. There may not be anything an attorney can do in this situation because you're not going to be entitled to alimony, but there may be other assets that you are entitled to a part of but we'd have to look at that and see what they are.
Definitely worth looking into.
Yeah.
There you go. All right. Very good. Well, I am going to, and I'm willing to put $1 on this, that I'm going to ask you the most ridiculous question you've ever been asked coming up in our next segment. I don't know why I just thought of this question, but it's kind of goofy. So I'll ask you here coming up in just a minute. Again, if you have better questions than mine, which I promise it will be, email us, ask@DeWittLaw.com, or by calling and leaving a voicemail, 407-53-MOSES. And again, if you want to call the office anytime for legal advice, something that you don't necessarily want to do right here on the show, that number, 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Right now, you guys, come to the stage. Please welcome Mo DeWitt. Mo DeWitt from the DeWitt Law Firm. Agent on go, just call Mo. Mo DeWitt, everybody.
What's on, Ross?
Thank you, Ross. I just want to thank all you guys for coming out tonight. It's been a great event for a great cause. It's all for the Yellow Brick Road. If you don't know what that is, look them up, ybrf.org. I think we got Juan and Trey in here tonight from there. So thank you for raising money for them. Thank you for coming out, and I hope you guys are enjoying the show. That's all I got to say. Thank you, Mo. Mo DeWitt, everybody. Get over, Mo.
Hey, thanks so much for joining us and listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. Remember, the answers given on the show do not constitute legal advice and do not create an attorney-client relationship. But for legal advice, you can call the office anytime at 1-800-DeWitt-LAW or interact with the show by sending an email to ask@DeWittLaw.com or by calling 407-53-MOSES or by hosting the show with Mo, where you can sneak in your own ridiculous questions like I'm about to do. As promised, one of the dumbest questions, maybe the dumbest you've ever been asked, but when we were talking our last segment, you were talking about marriage as a contract between two people, and you kind of giggled about two people. Every now and again, you hear of some ridiculous story in the news where somebody is in love with their an imaginary friend or a ghost, or they're in love with their stuffed teddy bear, and they want to go and they want to marry that person legally. Mm-hmm. Can that ever actually be done? Or does it has to be somebody or something that can actually sign their name on it? So sorry for the dumb question, but it just popped in my head.
Well, I mean, under the current state of the law, marriage is only recognized between people.
Okay.
And that is what the statute says.
All right.
So,
no matter how real that apparition is or that teddy bear?
Unless you're a person,
you're not getting married.
Happen.
Okay.
Yeah.
So there you have it. Dumbest question ever. Can I get credit for that? So you
we'll put that on your permanent record.
Somebody else asks you a dumb question, be like, not as dumb as that Jay Edwards asked me. All right, so here we go. This one's a little bit longer, and I'm going to do my best to try and convey this person's message. So hopefully it makes sense. Mo, I purchased a home with a friend. We're co-owners, both on the title and mortgage. We're not married, but we were together for a little while after buying the house. Things went south. We're no longer friends, and we're in the process of selling the house. I filed for bankruptcy last year, and the mortgage loan was discharged. Due to a hostile environment, I decided to move out of the house while we were selling it. The co-owner is threatening me with abandonment of the property since I'm no longer paying the mortgage and attempting to claim 100% of the equity in the house. So far, of the 18 months that we've owned the house, they have only paid the mortgage for 1 full month themselves. I contributed the other 17 months. Can they legally threaten me with property abandonment and claim 100% equity?
All right, so a lot to unpack here. So
yes, I only understand about a third of it.
Let's get to unpacking. Now, first thing that they say is that they filed bankruptcy and the mortgage was discharged. Mm-hmm. That's not true.
Okay.
So if you file bankruptcy and you have a mortgage, they can discharge the personal obligation, meaning they can't sue you personally for the mortgage. And many people out there may have heard of deficiency judgments from the foreclosure days. Basically back, still today, but in the foreclosure crisis, a lot of the mortgages were at a higher value than the property was worth,
yes.
Right?
Okay, yeah.
So the bank would foreclose on the property, but they would lose, they resell it, but they'd lose $100,000 on the property. And then they could go back and sue for that deficiency. They could sue the person for that deficiency judgment.
Okay.
So that's the part that's being discharged in bankruptcy. It's basically when you sign the note, that personal obligation, that's what's being discharged. Your mortgage does not actually get discharged. You still owe the money on the mortgage.
I got you. Okay.
And it's still tied to that home. So that's the first thing I wanted to correct there. And this kind of relates to what I was talking about in the prior segment. If you are, quote unquote, in a common law marriage, which again, Florida does not recognize, but you own property together, right? You may be entitled to a portion of that property. So first of all, there's no such thing as abandonment in Florida. So just because you move out of the home, legally, financially, you're not waiving anything from that property. You're not waiving your rights to it. You're not waiving what you legally be entitled to financially in a partition lawsuit. But what you're going to have to do is basically there's going to be a partition action file, which is basically an action where you ask the court to force the sale of the property. Typically, you kind of agree to assign a realtor to it so it's not auctioned on the courthouse steps because you don't get fair market value for that. But they're going to sell the property, and then the real question, there's no real doubt it's going to be sold, or one party can buy the other party out. The question is, how do you divvy up the proceeds, right? So assuming there's equity in the property, how is that divvied up? And that's where kind of testimony and receipts can kind of come into play as far as did one party put more money into the property than the other.
Right, because they said they paid 17 of the 18. Like if that was me, I'd be like, listen, I want it all. I want as much as possible.
But you got to prove that. You
Yeah.
got to prove that you actually paid that. So a lot of times people say, oh, I put all the money in, but maybe it was a situation where one person put the down payment down, but the other person was paying the monthly payment.
I gotcha.
And so then you have to kind of look at that.
The big picture.
Yeah, so there can be a lot of dispute over that. But again, you have to kind of get receipts, gather the proof, and see what's really going on there. Ultimately, though, the property is going to be sold. It's just a matter of how those proceeds get divvied up.
All right. I understand now. Much easier now that you explained it. Thank you. All right. Next question. Oh, this comes from Sharon. We have a name with this one. Sharon says, I have an approved proposal for a pool company that was signed back in 2021. Construction was set to begin about a year later or so. Fast forward to now. Construction is in like the second stage of it. However, the company reached out and told me that prices have gone up since we signed the contract, and now they want to add an extra charge of $10,000 roughly to our original price. I took out a loan for the amount that we agreed upon in 2021. Our understanding was that this number was not going to change since we even asked the question in our meeting, and now they're trying to pull this on us. Can they do this? I do have a copy of the approved proposal if needed.
So, I mean, that's the first place to look is what are the terms of the proposal? What are the terms of the contract, essentially? And does that allow for any price increases for materials and things like that? Assuming it doesn't, let's say it's a fixed contract. They say we're going to guarantee we're putting in the pool for this amount. I'm guessing it probably has some provisions in there that allow for cost increases, but let's just hypothetically assume that it doesn't. Then you basically have to make a decision. Do you want to try to hold the pool company to this contract? And they may walk off the job, and then you get into a lawsuit where basically you have to go hire somebody else, expend more money, have them finish it, and then sue the pool company. So it's really going to be a matter of math there as to whether that makes sense to do from a financial standpoint. I'd always recommend, especially if they're doing a good job, because, it's hard to get good people to do anything.
Show up and work.
Show up and work these days. If they're doing a good job, it may be a conversation that you want to have with them. And maybe they say, hey, this is the cost. We're giving it to you at cost or whatever it may be. If they're being unreasonable, then maybe you get a quote from somebody else and see what the difference is. But the first place to look is going to be that proposal, is going to be that contract to see if it allows for any price increase or price flexibility if there's changes in the market, which, I think, especially in PVC, which is obviously used in, pool plumbing a lot. I mean, that stuff went through the roof because a lot of the manufacturers got shut down. I think the one in New Orleans got shut down, or in Louisiana got shut down from the hurricane, right around COVID as well. And so they were having all sorts of supply issues with PVC. So, I know there's been a lot of issues in the pool industry in general, but that's the first place to start. Look at the proposal, look at the contract, and see what it says there.
Because even if they did say something verbally, you're like, no, it's going to stay. If
that's a good point.
If there's small print in there and you still signed it, right?
Right, that's a good point, because the person said my understanding was that the price would not increase. Doesn't really matter what your understanding is. What matters is the terms of that contract. And that's a good lesson for anybody is, oftentimes we have conversations with salespeople, we have discussions. At the end of the day, it doesn't matter what that person said. What is legally enforceable is what's in that contract that you signed.
Right. So that whole gentleman's handshake and then you turn around and sign it. You just put your name on a piece of paper with all the legal terms on it.
Yep. You better hope the person's a gentleman if they said something different than what's in the contract.
Fingers crossed are behind the back.
Yep.
All right. Next question is, okay, this one's kind of short here, so I'll get to this one. I was pulled over charged with DUI in December. I blew just over the legal limit, and I'm pretty sure there's no way out of this DUI charge. The question I have is this. I pulled over in a bad spot in the shoulder near a business entrance, and the cop said it would be towed. So I asked if they would move my car to a parking lot across the street, and they did. But when I got back to the car the next day, it had been clearly searched. My glove box was open. There was stuff on the floor. My seats were moved forward. Is this an illegal search, even though I let them drive my car? Is there anything I can do to hold them accountable, or is it even worth it?
So, I mean, first of all, you let them in the vehicle and let them move it. So
Hand
once
them
they're
the
in the
keys.
vehicle, you kind of gave them permission. But this is also kind of what we call a search incident to arrest. So basically, you've been arrested for DUI, right?
Mm-hmm.
So they can, search you for weapons. They can search the vehicle for weapons. If there's anything that's visible to them, they can search that as well. But I think arguably, the search incident to arrest aside, because there may be some arguments there, arguably you gave them consent to go in your vehicle.
Right.
So I think any argument may have been waived there that you did not give them permission to search the vehicle. Let's take the DUI arrest out of it.
Yeah.
If you hand the cop your keys and say, hey, you mind moving my car? And they say, sure. You've kind of given them permission to do whatever they want with the vehicle.
Yeah, I think maybe that their last question of is it even worth it? I think maybe they already knew their answer, but they wanted to know, hear it from you. All right, good one. All right, we got time for another. I am a U.S. citizen, Mo, and I married a non-U.S. citizen in Europe. Our relationship did not work out, and my spouse left me a year and a half ago. I'm thinking of starting up a new family eventually. However, I can't find her to serve her with a request for the divorce. She's got to be somewhere in the U.S., and I have an idea what state she might be in, but that's it. That's all I have to go on. What do you do?
So, I mean, we've actually had this case many times, and people are often frustrated with the answer, but it's frankly the only way to do it. So, and it actually happens more than you'd think for some reason. Yeah, I mean, I think people, sometimes they get married young, and then they kind of lose track of each other. They just never bother getting divorced. And then, 10 years later, they want to get remarried, but they're still legally married to somebody else. They got to go back and clean that up, essentially.
Surprise to their fiance.
Yeah. So, I mean, the first thing you have to do is a diligent search, right? So, because as part of this process, you're going to have to file an affidavit of diligent search showing the court how you've attempted to find the person.
Does that mean like I've called and tried to reach out to their family members or posted something on Facebook, or does that mean I hired a private investigator?
Well, a little bit of both. You always
okay.
start with kind of the least expensive means, which would be, hey, any family members, call them. You have any contact information, you reach out to them, things like that. Assuming you don't have that, that's when you kind of go the more private investigator route, where you start searching the postal database and property appraiser databases and things like that to see if you can find them anywhere. If you still can't find them, if they've completely vanished and you cannot find them at all, which does happen sometimes, then you basically have to serve them by publication. And so you have to publish in the back part of the newspaper that nobody ever reads for 4 consecutive weeks, basically saying, hey, we're going to move forward with a lawsuit for a divorce. We're putting you on notice. Once you do that, you can move forward to get divorced. Now, typically when you do that, you can't get really assets. You can't get alimony. It limits what you can actually get out of the divorce, but it can actually get you divorced. And usually in this situation, that's kind of what most people are looking
Just
for.
get me out of it.
Exactly. Just get me out of it. So that's kind of how you have to go about it. Now, you do really have to make that diligent search, because the court is going to look at that and make sure that you've actually done your homework to try to find the person, because, of course, the court wants to put people on notice. But there's also certain people who don't want to be found.
Right. Yes.
And we've had those cases before, too, where people have just disappeared to another country. They've taken a duffel bag of cash and they've disappeared, and they left their spouse and family here. And the spouse wants to get divorced eventually, and you have to go through this process. And even in some of those cases, we know where they are. You just can't get to them. And so then you have to explain that to the court and basically say, look, we believe they're at this place, but we've hired all these process servers. And the frustrating thing about this is, all this costs money to the person, right?
Sure,
the publication,
absolutely.
hiring the process servers, doing the searches. This is all an added expense that can be rather frustrating, because you feel like nothing's really getting done, but it's just part of the requirement of going through the process.
All right. So just a Facebook search is not considered a diligent search.
No, but I mean, nowadays, social media searches would certainly be part of it.
Right. I mean, hey, next thing you know, they put their names backwards and boom, look at you trying to hide.
go.
And there, I just found you. Real quick question, because we only have a minute left.
Yeah.
What if the person you were searching for turns out to be deceased? Is then that's just cut and pay? It's just done?
Right, then you don't need
Easy.
to get a divorce because they're deceased and you can just move on,
You just
essentially.
say, hey, that person's no longer living, and now I can just move on with
Yep.
it. Okay, interesting. All right, got a couple more questions. Plus, we've got our Mo Pro Tip of the Week coming up in just a few minutes. Mo, if somebody has some questions for you and they don't necessarily want to do it here on the air, what's the best way for them to get in touch with you? Website, phone number, if they want to maybe sit down with somebody from your team and get some advice.
Yeah, you can always find us at DeWittLaw.com. That's DEWITTLAW.com. Or you can give us a call during the week at 1-800-DeWitt-LAW, 1-800-339-4885. But if you do just have a question or, whether you want us to read on the show or not, and you can always use a fake name too, you can send us an email at ask@DeWittLaw.com or leave us a voicemail at 407-536-6737. So I know I just threw a lot of numbers at them, but those are kind of the ways to reach us.
Easiest way, DeWittLaw.com or ask@DeWittLaw.com. There you go, whether it's on the air or off the air. More of your questions, more advice coming up in just a few minutes. You're listening to the DeWitt Law Review on WDBO.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork, and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400, basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yeah, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with Mo DeWitt of the DeWitt Law Firm. Mo is answering your questions and discussing the latest legal issues affecting the citizens here of Central Florida and answering your questions and your emails that you send to us, ask@DeWittLaw.com, or you can call and leave a voicemail, 407-53-MOSES. Hopefully we'll have time for at least one or two more here real quick. Mo, my girlfriend of 4 years, has been separated from her husband for nearly 20 years. He has now, due to a relationship, contacted her about a divorce. We were just talking about something like this. I am of the opinion that having never received any support, that she is entitled to something. He has also liquidated a 401k plan that he had during the marriage, as well as selling vehicles that her name was on the titles to without securing her signature. After this amount of time, can she or should she seek some sort of financial settlement, payout, something like that?
Well, my favorite lawyer answer is it depends. That's kind of the case.
That's
here.
like a parent. We'll see.
Yeah, exactly. I mean, here's the thing. First we have to see how long were they married, what's the financial situation, how much was liquidated in the 401k.
Mm-hmm.
From a pure legal standpoint, if the 401k was 100% acquired during the marriage, let's say, then it would be a marital asset. It should be split equally, right? She should be entitled to 50%. But maybe she has something that he would be entitled to, and that offsets that. So we want to take a look at the financial picture as a whole, and then make a determination, is this even worth going after? So number one, just the dollars and cents of it, does that make sense to actually pursue the claim? And then number two, let's say you win on the claim, is there something there to collect? Does this person now have assets? Do they have money? Do they have property? Do they have something that you would possibly be entitled to as part of this divorce? Because the last thing we want you to do is throw good money after bad,
Right.
Chasing this guy down out of principal or whatever it may be. I would say you have to pay for principal. because, when you're pursuing a case just for principal, usually costs you a lot of money.
A lot of money. So, yeah.
Yeah. So that's kind of the issue there. So we'd want to take a look at it as a whole. But certainly, we've had cases before where people have been separated for 15, 20 years sometimes. Now, in those cases, at least the ones I'm thinking of, there was still financial support going back and forth. But it can be a little bit difficult to go back and kind of unwind that because, there's been a lot of assets added to the marital estate during that period of time. And depending on the situation, those assets may be considered marital or they may be considered assets that were acquired through that person's efforts after the date of separation. So it can become a little complicated when you start looking at it from that perspective. But really, you have to sit down as a whole and kind of evaluate the entire marital estate, then see what you could possibly be entitled to, whether it's worth pursuing that claim, and then ultimately, is it even collectible if you can win on it?
Does length of marriage matter? Like they were only married for 9 days. Well, still, you were legally married, or as opposed to we were married for 19 years.
Well, if you're married for 9 days, you're probably not acquiring a lot of assets during those 9 days.
Yeah, right.
And you're on a 9-day marriage, you're probably not entitled to alimony either.
Okay.
So it makes things, the shorter the marriage, usually the simpler the divorce, right?
I got you.
The longer the marriage, the more things that are intertwined. And so the harder or more difficult it is to kind of unwind those things and figure out whose is whose. So, yeah, length of marriage does make a big difference. It also makes a big difference when it comes to alimony as well.
My follow-up question now leaves us a little bit short on time for our Mo Pro tip of the week, but we got to get to it. What do you have for us?
Well, I'll make it a quick one because I know we're short on time. Something we talked about earlier, and it's something we're all guilty of, frankly. Anytime you're signing any sort of contract, especially for a big ticket item, a big dollar item, don't take the salesperson's word for it. Don't take the representative's word for it. Sit down, spend some time to read that contract. I usually like to tell somebody if they're trying to get me to sign a contract, hey, let me sleep on it. Let me read through it. I'll bring it back to you tomorrow. Usually if they try to pressure me and get me to sign it right away, at least in my opinion, I usually that's a red flag for me not to do the deal.
Yeah, that's a good
because
point.
that means that there's something in there that they don't want me to see, unless there's a really legitimate reason as to why I need to sign it right then, which is usually pretty rare. But there's almost never a reason why you shouldn't be able to review it overnight and get it back to them in the morning, and that way you can spend the time to actually read everything. You don't have to sit there with someone over your shoulder and make sure you know what you're signing.
That's a good red flag tip. Never thought about that. No. Do it now. I got to hit my numbers or whatever. Okay.
Right.
So I'm going to start using that. Thank you. That's
you
our
go.
Mo Pro tip of the week. All right. Well, if you do have questions for next week, ask at DeWittLaw.com. Or if you want to call the office anytime, 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. You're listening to the DeWitt Law Review on 107.3 FM and AM 580 Orlando's